right, it's 11 o'clock. Let's go ahead and get started with our excellent webinar today. Mountain States Legal Foundation is very happy to bring you this webinar about hot topics in natural resources law and how government overreach is playing out with our nation's natural resources. We're excited to have two incredible panelists with us today, and then me, not so incredible moderator, but I think I'll have a good experience with Doug Benevento and Ivan London. Let me first introduce Ivan, who is the head of Mountain States' Natural Resources Practice Group and previously in private practice at places like Bryan Cave doing energy and environment work. And then Doug Benevento from Holland & Hart, which is a prominent law firm in Denver. Doug previously served as a senior executive in Excel Energy, and then also as a member of the Douglas County School Board, which is how we met. And then more recently as the acting deputy administrator of the EPA, and now as a partner in the law firm of Holland & Hart. So as I've said before, Doug is a true Renaissance man, and I'm looking forward to the perspective he's going to give us today. With that,
if I could interrupt you, I think it's a better way to describe me as a guy who can't hold a job very long. So
yes, well, it's possible that you may be called into service again sometime soon, so we'll see. Well, let me open the floor, Doug. I think we'll start with you. Our topic is hot topics in natural resources law, and then also government overreach and what's going on these days in terms of energy and environment. And I wanted to get your broadest picture in terms of what you're seeing and what trends are out there that our viewers might be interested in.
Sure. And first, thanks for asking me to participate. I really appreciate it. And I just want to give a shout out to Mountain States Legal Foundation. It's an organization that has been around for a long time, and they've just done really good work. I think holding government accountable to the to the regulatory authority that Congress has given them, or state agencies for that matter. And so it's a really important organization, and it's one that everybody should support. And I'm glad to support you guys, and I'm glad to be here. So the most natural thing, when you ask that question, the most natural thing that comes up to my mind is, okay, what were we doing during the Trump administration, and how were we approaching environmental law, natural resources law? And then how is the Biden administration doing it differently? And, there's the really obvious answers that you come up with. They want to set an example, an ozone standard at, 68 parts per billion. And we think 72 parts per billion is what the science supports. And you sort of get those, standard issues that go back and forth between administrations and what you think the science will support. I think there's a deeper answer to that question, which is sort of how do you view your job as a regulator? We took a really kind of strict approach to how we viewed our job. Our job was to implement the laws that Congress wrote. We weren't sort of outcome oriented, though we wanted good outcomes. We were really sort of authority focused. What are we allowed to do given what Congress told us to do with a reasonable interpretation of the law? I think the Biden administration has taken sort of a much different approach, and I think that they would agree with this. I don't think that there would be a big debate. They're very much outcome driven, and then they try to get the law to go where they want it to go in order to reach the outcome that they've determined. There are some really good examples of this. I think if you look at the recent greenhouse gas regulation they put out under Section 111 of the Clean Air Act, you can see that's definitely outcome oriented. Though I would say, given that the Supreme Court, recently decided the major questions doctrine, I think they tried to ramp themselves back a little bit to not do as much as they would have done otherwise. But that's a good example. We did a similar 111 rule, and we basically looked at the law. Were pretty clear to us what we thought it said, and our regulation was significantly different than theirs. But a better example, and one that's going to be more timely, and for practitioners in the environmental field, whether frankly you're doing natural resources or whether you're doing Clean Air Act, federal statute, and federal EPA statute law, is environmental justice. There's no doubt in my mind that environmental justice is a real issue, that there are areas of the country that haven't benefited from the implementation and protections of environmental law as much as other areas have. And we were very, very aware of that in the Trump administration. We spent a lot of time in making sure that we were moving forward with Superfund cleanups, with SIP development by states, in order to ensure that all areas of the country were being protected. The Biden administration has taken a different approach than us, which isn't surprising, but they've also taken, I think, a different approach from all past administrations. If you look at what they're doing with environmental justice and with Title VI of the Civil Rights Act, they're basically creating a new sort of procedural statute, almost a NEPA-like statute that you need to satisfy before you can get to down to the substance of the law of getting your Clean Air Act permit, for example. And a really good example of this is a memo that they put out a couple of years ago to federal, state, and local permit writers, where they basically said, and I've got it pulled up, but they basically said that if you do a Title VI analysis, and you find that you can't come up with and you find that there's a disparate impact, and you find that you can't come up with a solution to it, that Title VI of the Civil Rights Act would be a basis for denying a permit.
Wow.
That's new.
Yeah.
And that's significant. Now, there's been some litigation on this, and I'll stop in a second because I don't want to monopolize the time. But there's been some litigation in this. In the last week, I think it was the Fifth Circuit out of Louisiana made some decisions on this that looks like it could potentially slow down EPA's interpretation of how to use Title VI in environmental justice. But the point being is that what you're seeing is something new. You're seeing the development of basically a new environmental law, and it's flowing out of Title VI and environmental justice, and is creating new procedural requirements that all practitioners need to be aware of. I don't care if it's if you're trying to get a BLM permit to operate on BLM, to do oil and gas development on BLM land, or if you're applying for a Clean Air Act permit, that there are some new procedural requirements that EPA is expecting, and that folks need to be aware of. And that's a significant difference between what we were doing and how they're approaching it. How we were doing environmental justice and implementing the laws, and how they're doing it. They've created, and I think it can be argued, and I think the Fifth Circuit sort of indicated this, created a new procedural requirement out of whole cloth that you need to satisfy before you can actually get down to the substance.
Wow.
So I'll stop there.
Well, I want to turn it over to Ivan in a moment, but I did have one follow-up question for you, and I should mention for our audience, if you have a question, go ahead and put it into the Q&A box, and we will have time to get to some of the audience questions. Ivan, did you want to address
I'll jump in with a quick, brief question just to say, I don't mind him. I'm not monopolizing the time at all. It's great to listen to and great to hear. It's an honor to be here with you, Doug, and to hear your perspective on things, and just, jumping in real quick on the point of the changing administrations. It's difficult. We do a lot more on the litigation side, where sometimes, for example, we deal with the DOJ, and their line lawyers don't change positions that much when you might expect them to. Other times they say, our client's changed, our hands are tied, right? Our client used to think this, and now they think something else. So I'm glad you brought that perspective.
Yeah, Doug, just on that point, how do you, so Title VI, I mean, that's a broad federal civil rights statute that I'm familiar with in the education context. Schools can't discriminate. How do you prove in the environmental context that something doesn't disparately impact a racial group? How do you prove the negative?
For folks that are aware, the Title VI, again, part of the Civil Rights Act, and it prohibits the use of funds, federal funds, for discriminatory purposes. And there's direct discrimination, and then there's disparate impact. And so, some of this is Louisiana is litigating a lot of this right now, and it's really worth following that litigation. So, obviously it's clear that you can't say, well, we're not going to give money. We're going to use this money to discriminate against a certain group. It's flat out can't do that. There is the disparate impact analysis are the effects of, say, a state regulation, and it does not apply to EPA, but applies to state and other recipients of federal funds. are the recipients of those, or is a regulation or say the issuance of a permit have the effect of discriminating against a certain group? In which case, there's a disparate impact analysis that you can do that would, that EPA believes would tell you whether or not that is happening. So it is, there's an analysis that can be done, and it's not probably, and again, reading the Louisiana litigation is probably not as clear as folks would like. There was a permit, and this hasn't been resolved yet. There was a permit that was issued by the state of Missouri, and it was challenge, a outside group brought a challenge to that permit for a disparate impact, and EPA is currently looking at whether or not that permit can be issued. So there's to answer your question directly, how do you make that determination? There's a disparate impact analysis. There are criteria to do that. It's not as clear as maybe I'm making it sound, but there are some standards that have been set up around it. But again, this is and outside of the educational context, this is saying that, this statute overrides the Clean Air Act or the Clean Water Act. And it is and it's been pushed back. There's been a lot of pushback that's been occurring in the last year. And so EPA's backed off a little bit, but it appears that they may have backed off based upon the jurisdiction that it would be litigated in. As the court noted in Louisiana, when ruling and when making a series of procedural rulings, we're finding that that Louisiana has standing to sue because yes, you may have pulled this. You may have pulled this complaint or this litigation against against Louisiana, but you're in other parts of the country, you're saying it still applies. So the court basically said it looks like you're pulling this because you don't want to be subject to our jurisdiction. Therefore, we're going to go take it.
Yeah. So I'd heard a little bit about this because the federal government got nervous that they're in the Fifth Circuit, which is the circuit that's based in New Orleans and covers Texas and is a little bit more conservative in terms of which political party president has appointed more of the judges. So it's interesting that the Fifth Circuit didn't say, okay, you can pull out. They kept the case.
Yeah.
Okay. Well, Ivan, I want to transition a little bit to some of the legal trends that you're seeing in the natural resources practice group. Doug's already mentioned the major questions doctrine. We also have the Chevron case this year called Loper-Bright, which involves how much courts need to defer to executive branch agencies' interpretations of statutes. And then just in the last term, in a case where Mountain States filed an amicus brief in the Sackett case, the court addressed what counts as a wetland. Do you want to address some of those legal trends and what you're seeing in terms of the reverberating effects of the cases?
Yeah, I'd be happy to. I think in trying to be brief with my time because they can be complicated cases, but with complicated outcomes. And I've certainly been in several meetings, for example, with the DOJ, where we might not agree even now about what those outcomes are. There's a lot still to be decided. On the deference issue, the Loper-Bright case, which, the briefing we did this past summer, was argued here a couple of weeks ago at the Supreme Court. There are a number of questions. The one we focused on is helping ordinary people, including our clients, have a fair shake at the courts when they're going up against the federal government and some question of interpreting the law. I think kind of the bargain we have here in our Constitution, I think some of the justices have spoken to this, is that if a federal regulatory body wants to enforce some rule on you or tell you what the rules are, and you don't agree with them, there's a neutral third party, the federal judges, who will listen fairly to both sides and decide what the law actually says. And over the last 40 years, basically, the courts have sometimes gotten away from that. And so the cases that have kind of been bubbling up now for about a decade, and some of the opinions that are statements from justices that come down, I want to readdress that. And I think we stand for that. And that's the issue we briefed. The question of whether the federal government should get kind of a thumb on the scale when it comes to interpreting the laws, or whether there's some other approach that maybe is a little more neutral, in our opinion, at least, and more appropriate, so that when we're representing our clients in a dispute, we feel like we're getting a fair shake. So that's the Loper Bright case that's currently pending. Now, in the second case, that's a similar question of what can the regulators who are trying to enforce some law, and maybe the best intentions, what jurisdiction or what authority do they have to do it when you're on your own land and trying to maybe make land improvements on your property? So the second case has been one that's been around for decades, like literally, I think almost literally 2 decades ago. A couple named the Sacketts bought some land in northern Idaho and began to kind of fill in some wet spots in their land, if you took it, take it a certain way, to build a house. What ensued was 2 decades of challenges from federal agencies, primarily the EPA, saying that they couldn't do that without a permit. And they didn't agree with that because there was there's a lake maybe a couple miles away. There were some wet spots in their land. There's a small creek nearby. But in what sense was this federal land? It's state land, or then it's their property. And so this question kind of kept bubbling up. And there have been many, as anyone probably listening to this knows, a lot of Supreme Court decisions and other kind of regulatory statements about expanding or contracting, or kind of making a confusion about what is the bound of the federal government's authority to tell them what to do with their land. And this past May, the Supreme Court tried to step in, I think, definitively, and we'll see if it's definitive or not, with a ruling about jurisdiction, which is that, hey, the federal government is supposed to have regulatory authority over traditionally navigable federal waters. And I think even Justice Thomas in his concurrence would go farther than that and say, hey, can you actually navigate it? But that term might be a term of art in this context. But I think if an ordinary person would think of a river or a lake or an ocean, right, and know what that means, there's no question, according to the court, that some of the wetlands that are touching those bodies of water are basically so intertwined with those bodies of water that you don't know where one stops and one starts. And Congress actually seemed to provide for that in some of the statutes. So some wetlands are also within the jurisdiction, but the approach that at times the federal agencies have taken has been very expansive. So it would cover every body of water, or even not body of water, every dry piece of land that might get wet sometime somewhere. And I think really so what the court said basically was, look, if it's a lake or a river or something like that, you can navigate in a traditional and ordinary sense. And then if it's some wetland that's just touching it, the idea is a continuous surface connection of water. Well, that's going to be within the federal jurisdiction, federal authority to regulate it. Otherwise, it's not. And all 9 justices agreed, at least in this case, the Sacketts land in particular, was not. There were some wet spots there, sure. There's some creeks nearby. Eventually, there's a lake nearby, but their land was not within the federal agency's authority to regulate. Although, like I said, the devil could be in the details. So what does continuous surface connection mean now? And issues like that I think we're seeing have not been maybe adequately resolved. I want to give one take, which I think what the court was doing, although I'm not sure if it explicitly said it, was take the perspective of, for example, the Sacketts, a property owner. Would an ordinary person look at, moving some dirt on their land and think they're maybe committing a federal crime? And I think they want to give a clear rule that said, no, it should be really clear to you whether you're committing a federal crime or not by moving dirt around your land. And we'll see if the agencies at least currently take that same approach, because I'm not sure they do.
Yeah, I was surprised that case came out 9-0, because I listened to oral argument and it seemed like there was a very stark division between the justices. But as you point out, at the end of the day, it is unreasonable to think that someone might accidentally commit a serious federal crime just by moving dirt around on their property. Doug, I want to well, first of all, let me remind the audience that if you have a question, go ahead and submit it in the Q&A box at the bottom of your screen. We already do have 2 questions pending. I can see they're spicy ones. So if you want to get in the queue, go ahead and do that now. Doug, at the beginning, you said that you do agree that the environmental justice is an issue. I've sort of been reluctant to adopt that phrase, environmental justice. Should liberty-oriented law firms and individuals have any heartburn about the idea that phrase maybe is being used to further some of the Biden administration's more aggressive overreach?
Yeah, I think that's a good point. A lot of these terms become sort of take on take on certain characteristics. And so when you use them, it can be assumed that you're talking about it in a manner that is, well, from our point of view, sort of inconsistent with what, sort of the law would allow. We didn't, to be honest, we didn't talk about environmental justice a lot in the Trump administration. We had an environmental justice office and we had environmental justice grants, but really what we talked about was where are we not getting our job done? You don't need to look far to see where the job's not getting done. There was a small Superfund site down in Pueblo. It's small, 2 operable units, and I went down there and visited, and it's in a poor area. A lot of English as second language, a lot of renters, and you go down, you look around, and it's really cleanups being done in yards based upon historical mining activities, smelting activities. So you went down there and it was, okay, how long this is a small site. How long is it going to take to get this thing cleaned up? And, by the time you sort of got the answer, it was going to take 15 years to clean up all the yards. And it's like, that's kind of bullshit. I mean, we should be able to move a little bit faster than that. And so we did. I went back to headquarters, said, hey, I'd like to get some more money for this. I worked with the deputy, soon to be administrator Wheeler, and we lined up money and we expedited cleanup about as fast as you could do it, given the logistics. That's environmental justice. That's seeing that there's going to be a lot of kids playing in a lot of yards with a lot of heavy metals over the next 15 years, and that has a potential impact. We should be cleaning that up. And we did. And if you go to some like the Navajo Nation, uranium mill tailings cleanup down there should be a priority. And it really wasn't. And, when I was at EPA, we moved some folks over to that to speed up cleanup there. So really, I mean, what you're talking about is, you're not going to find a Superfund site in a lot of good neighborhoods. What you're going to find Superfund sites are going to be what people would call communities with environmental justice concerns. What we wanted to do was find those sites, expedite cleanup when they're moving too slowly, and then get them delisted so that you had a community that was healthy. I mean, I spent a lot of time in Montana because that has a lot of Superfund sites, and up in Butte, I think they were listed, one of the first sites listed under Superfund. They were, I think it was 1983 listed. It was 2017, 2018. I mean, I made a point that, why are we moving so slow on this? And, people really, there weren't great explanations, and you could move faster. And sometimes it's lighting a fire under the PRP to get them move faster. But really what you're talking about when you're talking about environmental justice, you're talking about the agency just doing its job. The agency doing its job quickly, and leadership of the agency prioritizing work so that you get the most environmental and public health benefit from the cleanups that you're going to do. So I get your point is going back to your point, it's a good one. When you say environmental justice, it can be interpreted to mean, agency overreach, when what it should mean is the agency just doing its job.
Yeah. Well, I hope the media gave you the appropriate amount of credit for all the good work you did on those Superfund sites.
Yeah, I find working in the Trump administration, we often got a lot of pats on the back.
Well, I want to give you both the next question, which is there's a lot of talk about energy independence right now. And of course, the idea that we may have been energy independent, not relying on foreign oil, not relying on rogue nations or other places to produce our energy. And the idea, I think now, is that we are not anymore energy independent. But I would love to get your takes respectively on the truth of those claims, and then second, what the future looks like for energy production in the United States. Doug, why don't you start us out?
So I would turn to Ivan about whether or not we're actually energy independent at this point. Over the last few years, I've been in Colorado, and I know that there's been a lot of concern about and you can go talk to, Dan Haley, and he'll help, and he'll provide you the stats. The slowdown in permitting in Colorado has most certainly caused a reduced production And that's fixable by going back to a rational regulatory scheme. So it is confounding that we're not doing everything we possibly can to produce more oil and gas in the United States, and we talked about it a lot during the Trump administration. But it's true. The more oil and gas we produce here, the better the environmental benefit because of the restrictions that we have. Colorado is let me use Colorado as an example, since we're all from Colorado, presumably on the call. Colorado has, I think they're about to put it into statute, a 97% emission reduction target by 2040. So they want to reduce economy-wide all emissions by 97%. I question whether they can do it. I don't think they can. The governor's goal for utilities is 100% renewable, I believe, by 2040 as well. That definitely can't be done. But look, taking the first goal, which is a net emission reduction, if you have any hope of doing that, you're going to need natural gas. You're going to need a lot of natural gas. And to not be encouraging production of in-state natural gas to help meet that goal has two negative effects. One, you're going to be getting natural gas from another state that is likely not going to have the same restrictions as Colorado, and will likely be done in a less environmentally sensitive way. And second, you're hurting Colorado's economy. So there seems to be a bit of there's a bit of schizophrenia sometimes when it comes to energy production and emissions reductions goals. You can't say we're going to get rid of oil and gas and we're going to have a reliable, cheap energy supply, and also you're going to achieve these emissions reductions. You need to be encouraging more natural gas to get to where you want to go if you want to get to decarbonization.
Yeah, well, if you pick a date far enough in the future, no one can prove you wrong, right? If you say, the New York City will be underwater by 2150, that no one can say, well, that's just not going to happen. Maybe it will. Okay, well, Ivan, let me get your take then on energy issues and what trends you're seeing.
Doug said schizophrenia. I mean, cognitive dissonance also works, right? Just the two things, you can't hold the two things in mind at the same time, which is challenging. Now, I've been fighting these issues for more than a decade, often for producers, but heavily regulated producers, and helping them stay in business or get into business, despite all the constraints they face, and which they all want to meet, right? They want to be in business and they understand their obligations. And what we're seeing right now, though, I think it is different. It's meaningfully different, especially with the current administration's push. And when we litigate here at Mountain States, often we do handle state level issues, often of government overreach by any of the three branches. But most often we do see federal executive branch overreach. And here in the West, what we're dealing with a lot recently is trying to convert federal statutes that require multiple uses, including real promotion of federal oil and gas development, and converting them not just to a conservation use, which one could debate maybe if they want to get in the weeds of whether conservation is a use under the relevant laws, but more importantly, an anti-use, which is definitely not in the law. And you see a number of rulemakings we've been a part of, commenting on those rulemakings with an eye toward litigation, including even just recently at the kind of this, the more local level. We're talking about a BLM field office rulemakings, where we really have taken issue with this big picture, all fronts push to take away multiple uses and turn them instead into an anti-use agenda of public lands. And one way of saying it is taking public lands away from the public. Certainly not good for energy independence or development of the federal oil and gas state. Again, there are many laws that Congress has passed that suggest it's a priority to actually develop these oil and gas resources for the better of our country. So whether there's energy independence or not now, it's a moving target, depends on whose stats you like, kind of thing. But the big picture, at least, especially, both on the state level, as Doug mentioned, and certainly there are things going on, for example, New Mexico to mimic Colorado, but also certainly at the federal level has been to take uses that are beneficial for the public away from the public.
Yeah,
I'm getting nods, so I appreciate that. That's good. I like that.
Bringing me back to my days in Allard's office when I worked in Congress, where we always made the offer that, yeah, look, we'll do a big wilderness bill, shutting off a lot of these areas if you'll do a big release on the rest of the study areas. So let's settle the issue once and for all. We can get a wilderness bill done, protecting those most pristine areas that everyone would agree to. And then the study areas, which are managed as wilderness areas because they're study areas, release those for multiple use. And you could never get it done because it locked up land, the land, presumably people wanted the land to continue to be locked up.
That's, I think, seeing a current, reinvestigation into that push, right? And so, certainly I think everyone could agree that there are some areas that should be kept pristine or conserved in certain ways, and others that don't need that and would benefit the public by being used, which Congress clearly has foreseen and not just advocated for, but made law.
But right, well, the perverse outcomes of a lot of this really do damage the environment. So there was an instance, it was it had to be 2019, I think, where then Governor Cuomo of New York refused to allow I believe it was an oil pipeline to run through his state to bring oil to, I think it was Massachusetts. He basically stopped it, and it would have moved domestic oil to a domestic use. And when he basically vetoed the pipeline, Massachusetts said, "Fine, we'll just get it from Russia." And so what happened is they brought in oil from Russia. It made no sense at all. Again, it made no sense from the standpoint of environmental protection or sort of economic development in the United States. And I think California, you see that now too. California has some fossil fuel resources, and I always use California as an example. And I worked on a paper with Common Sense Institute along these lines. I compare us to California because our goals are basically the same, though they're probably a little bit out in front of Colorado. They are, they use a ton of natural gas. They have natural gas that they could use in state. They could put restrictions on the development of that natural gas to ensure that the environment is protected, but instead they opt to take it from other states and perhaps even from out of the country. And it makes no sense. But that appears to be the direction that we're heading.
We do have quite a few questions, so let me switch gears and ask a few of these. If you have a question, go ahead and add it to the Q&A box. The first question actually seems like it's maybe from a proponent of the Title VI structure, Doug, that you were referring to. We have a question that says, in the Idaho Lava Ridge, racial minorities were insufficiently consulted in the scoping process, and that there were not enough translations of various documents into foreign languages. So is that project vulnerable to your Title VI commentary from before? You don't have to say yes or no, but if you want to tackle what issues might be in there.
Yeah, so it may be vulnerable just on there are a lot of the laws, and the statutes governing the BLM I'm less familiar with than EPA, but most of them do have built-in public notification, public sort of public notice requirements. So if you were looking, if that were in fact true, that would be bad, by the way. And I've been on the other end of that, where you have a developer that doesn't want to engage with the community, and they don't, and that is a bad thing to do. And we always tell people, no, you got to go back and engage with the community. But if they in fact didn't engage with the community, they were communicating in a manner that was wasn't consistent with how, a lot of Spanish, you'll have a Spanish speaking area, you should be able to communicate to the community in Spanish. So I would, whether that's a Title VI issue, I would first start with the requirements for getting a permit to operate on BLM land and see what the public notification requirements were. And then, and if you had a right of action there, use that one. And I just want to emphasize, you should be communicating with the public. I tell clients this all the time. It's a time, place, and manner. Are you communicating with the public on a time that works for them, in a manner that they understand, and in a place that they can access? And this is sort of in most environmental laws, is a fundamental right people have, and it should be protected. And like I said, I've been on the other side of this, where you have communities just up in arms because, you know, you have somebody who's doing some significant, you know, development and not talking to the community and not telling them what's happening. And that's the job of the developer to do it. So I would first start with the BLM statutes.
Well, the next question is definitely on the opposite side of the spectrum. Given the regulatory abuses of the EPA, should we start thinking about challenging its constitutionality as an executive branch agency, where in Article 1, Section 8 of the Constitution, is there a power to create an EPA? Commerce Clause seems like a bridge too far, the commenter says. Has this ship sailed? Do you see any nascent movements to try to challenge the EPA, given the latest agency reforms maybe coming out of the courts?
Yeah, I would. I do think that the president has, and this is EPA is basically a presidentially created body. And I think he has the authority to say, hey, we're going to have an EPA to house the to house the implementation and enforcement of certain statutes. And that's really what it was. You took at the time it was created, I mean, a Clean Water Act, Clean Air Act, a couple other statutes, and you put them under one agency for administration. I think if you were to challenge, and I don't think there would be a challenge, people have talked about it, but you would really challenge the underlying statutes that the agency implements. If you're seeing overreach not because there's this thing called EPA, you're seeing overreach because the statutes as they are written are not being faithfully executed by the agency. So I wouldn't see much hope in challenging, whether an EPA should exist. What you're really talking about is the agency faithfully executing those statutes that it oversees.
Yeah,
I would, if I could, just dovetail on that a little bit. First, by noting, I'm not sure if Will meant the pun of the ship has sailed, but that was kind of the thrust of Justice Thomas's concurrence in the second case, right? And that goes right to Doug's point, is on a more of a statute by statute basis of a what are we doing here question, rather than addressing the EPA, as Doug said, not created by a president, but to enforce these federal laws. In that case, Justice Thomas was concerned that we're getting away from, can a ship actually sail here? And when we're talking about Clean Water Act jurisdiction.
The next question asks about the increase in state and federal government emphasizing electric vehicles and the need for certain minerals in order to make those vehicles and make them functional. Ought there be, or is there any action on expediting mining permits to ensure that metals, like I think copper is one of the main metals, are available, given the wave of electric vehicles coming on the market? Do either of you have a take on mining issues?
Not really. And certainly, mountain states, we're going to be more inclined to get involved at the sharp end of the stick when things haven't gone well than in my prior 15 or so years of practice, where we were also on the regulatory and permitting side. So I can't speak from experience right now whether mining permits are being sped up or held back or somewhere in between. It probably depends on who you're talking to and which office they're dealing with.
It is a super good question because I haven't seen the data on this, but I will repeat what I've been told, but I believe be credible sources that we source a lot of the material from out of the country. People have said China for the resources and in many cases the sort of end product that go into EVs, when in fact, why can't we do that in the United States? I think you're seeing that question brought up not just with mining for critical minerals necessary for the energy transition. You're seeing it also, as I said, for natural gas development, which is, if you want to have renewables, you need to have a reliable backup source of power, base load that is there to fill the spots when the renewables aren't working. And batteries technology, storage technology isn't quite there yet. So you're seeing this is a really broader question than just mining. It's true across the board. If you want to move to cleaner resources, you're going to need a lot of the traditional resources in order to make sure that that happens. And I think cognitive dissonance was a great way to put it. Ivan, up until recently, there's been the ability to ignore the need for natural gas and for mining for the energy transition that is being pushed really hard. I think we're hitting the point where it's kind of impossible to ignore that now, because you're needing more of those resources to continue to make the progress that you want to make. So it's a policy question more than a legal one. And the policy, I've talked to some friends back in DC who work in the mining industry, and they say they're seeing some at least acknowledgement that they are necessary. I don't think they're seeing a lot of substantive action that is freeing things up.
Our final question is about our favorite topic, grizzly bears. Grizzly bears are protected. They're also very dangerous, if you've ever encountered one. And some states have really pushed hard to completely delist grizzly bears, given the dangers to ranchers and hikers and anyone really who goes into the wilderness and may encounter a grizzly bear. What is the state of grizzly bear litigation, and do you expect there to be movement, either one of you, any movement on whether, for instance, if there's an imminent danger, a grizzly bear can be killed, or if there's a danger to livestock or something? What is the next big hot topic on grizzly bears?
We have another hour, right?
I have nothing on this other than if I'm imminently endangered by a grizzly bear, I want to preserve all of the rights I have to get out of that imminent danger. Ivan, I'll turn it over to you.
You're ready to commit a federal crime, Doug. Yeah.
And I'll keep mine short. I said we could have another hour, but let's not do that. The answer is, I know that the issue of grizzly bears is a complicated one factually, because of the locations of bears at times within the United States versus in other countries, like, for example, Canada. And the question of whether they are truly endangered, whether they ever covered in the United States, whether they're ever actually endangered in the United States, is because they've changed where they live. We've been litigating these things often. Will and I, at least, in the last several months, have had a couple of victories in the Ninth Circuit federal court and the 10th Circuit also, protecting ranchers primarily from grizzly bears. I know that there has been at least proposed federal legislation, but I don't know what the status of it is, to delist certain small groups of grizzly bears from the overall grizzly bear endangered species listing. There is also a push, I know, up in the Northwest, to delist all of the grizzly bears in the United States, because the grizzly bears that are listed as endangered in the United States, and I know we're getting the weeds here, are only listed for the lower 48 states, which is to say, well, what if they're not endangered somewhere else and it's all the same population? One of the little weird details is that they come down from Canada and they kind of split out here this way. So is any given finger its own population, or is it all just part of a robust grizzly bear population that is no longer endangered? The truth is, I don't know the status of some of those efforts, except that I know that they've been proposed. There's been litigation proposed. Some may be filed. Federal proposed laws, at least sent to committee, regarding whether to delist at least certain population segments of bears. And then other states seeing that and saying, hey, wait a minute, that leaves all the endangered bears with us. That's no fun. So it's it's a grizzly topic. That's bad. I won't do that again. It's a tough one though, and I don't have exactly the current status of what's going on at the federal legislative level to know exactly, kind of give a direct answer to that beyond what I just said.
Well, it seems like we need to build a wall on the northern border to protect us from the Canadian bears coming down. With that, let me offer you both maybe 30 seconds in terms of closing thoughts about trends or government overreach, and then we'll go ahead and close it out. Ivan, do you want to start us off?
Oh, sure. It's been an honor to hear from Doug and to be with you guys. It's been, I think I've learned plenty, even just sitting here, and I've enjoyed sharing kind of some of my thoughts. it'll be really interesting to see what the Supreme Court does, for example, with the Loper-Bright, the Chevron deference type cases, and whether it sort of resets or completely changes or leaves in place the current sort of theme of federal judges sometimes giving a reflexive thumb on the scale in favor of the federal regulator when there's some question about what the law is. Certainly not all judges do that, but a lot of them do. And so we've asked for at least a clear instruction to the lower courts to listen to both sides equally. And I mean, since I talked at length about Sackett, I think that there's going to be separate precedential components to the next steps with Sackett, whereas the court was trying to create a clean rule, a clear rule that your average person can follow. And like I said, know whether they're committing a federal crime or not. I don't see the current regulators maybe following that. And I think maybe they're changing some of the way they speak about the issues to substantively not follow that. And I do actually, I don't want to give them any tips, but if I was to compare Sackett with the Maui case that was termed before, I believe, there might be some question whether the significant nexus test is really dead. So stay tuned.
Okay.
Yeah.
Doug?
Yeah, Chevron, of course, is going to be, everybody's going to be breathlessly waiting for that decision in the Loper case. I think you're right. Watching the development of Sackett too is going to be fascinating. And then, you know, how do the states manage it?
Mm-hmm.
It is really going to be fascinating to watch. Finally, you know, I am watching sort of Title VI litigation. It is what's happening in Louisiana is very interesting. EPA quietly has asserted a lot of authority, new authority under Title VI that you can't find in any of the environmental statutes, and seeing how the court sort of sorts its way through all of that is going to be really, really interesting because the outcome is either going to be, you know, a definition of what Title VI applies to. Potentially, that could be create, again, a new procedural-like statute that people would have to be aware of.
Great point.
Well, this has been an incredible event. We're so happy to have Ivan and Doug talk to us about hot topics in natural resources law and government overreach. Thank you to all of our attendees for being with us today. Please stay tuned for our February So a Neighbor Asked webinar. If you are interested in learning more about Mountain States Legal Foundation, you can go to our website at mslegal.com and you can find out all about the cases that we talked about here today and all about the issues that Mountain States is facing, both in terms of government overreach and in hot topics. And we will see you next month. Thank you again to our fantastic guests today. And we look forward to seeing you again soon. Bye.
Thank you.
Well, Doug, great to see you.
Yep. Good to see you, Ivan.